Now, the Supreme Court will on Monday deliver a judgment on the validity of the October 26th repeat presidential election. Tonight, political affairs reporter Mrimi Mwangi highlights the likely scenarios and why tomorrow's verdict could redefine the future of Kenyan politics.
As the Chief Justice David Maraga chaired six-judge bench walks into the Supreme Court on Monday,
Gentlemen,
in their hands will be a verdict either validating or invalidating President Uhuru Kenyatta's re-election during the October 26th repeat poll that was largely boycotted by opposition supporters. A boycott that saw the repeat poll failing to take place in at least 27 constituencies.
A national election for the president has to take place in all the constituencies. 290. Now we have 291 because of the diaspora.
To say that we are only going to conduct an election in some parts of the country and leave out other parts because in those parts there is violence is to divide this country. It's to balkanize this country.
The judicial process has been converted into another political battleground. That is something the court must resist.
In their verdict, the judges will also be grappling with the key query on whether electoral body IEBC ought to conduct a fresh nomination of candidates before proceeding to the polls. The first petitioner, former Kilome legislator Harun Mwau, claims all the 8 candidates listed on the October 26th ballot are strangers, having not been freshly cleared to vie. An argument also fronted by activists Helef Khalifa and Njonjo Mue, who argued that opposition leader Raila Odinga's withdrawal on the 10th of October necessitated a fresh nomination and a subsequent election in 90 days. The petitioners also questioning inclusion of Cyrus Jirongo's name on the ballot, despite not having been among those initially gazetted to participate in the repeat poll.
The question of Jirongo and when he came into the contest are not matters which have been raised by the candidate or any of the other presidential candidates. They cannot be introduced by a signed word.
Nomination is an essential part of the election itself, which affects the outcome of the election. That was an admission given in open court, publicly, and voluntarily.
Nobody has approached any of our courts complaining that he or she wanted to stand for the presidential elections on the 26th of October and was denied the opportunity to do so.
Should the judges nullify President Kenyatta's win again, Article 140, subsection 3 directs that IEBC should conduct a fresh election within 60 days from the Supreme Court verdict. A scenario where Kenyans would head back to the ballot by 20th of January. But should the Supreme Court uphold Kenyatta's win, then his swearing-in should be on November 28th. This being the first Tuesday following 7 days after the verdict, as stipulated in Article 141, subsection 2b. Odinga's camp, though not a party to the ongoing petition, has vowed to reject Kenyatta's legitimacy as president if the court rules in his favor.
When the court on 1st September directed that we have another election in strict compliance with the Constitution and electoral laws, it just meant that, so that if there was no election that was to be held in strict compliance with the Constitution, there was no way in which NASA would have participated in that election.
As the crisis following the October repeat presidential poll intensifies, the Supreme Court is yet again on the legal, political and diplomatic spotlight as the bench prepares to validate or invalidate President Kenyatta's re-election. Mrimi Mwangi, KTN News, in Nairobi.